Top Med Talk.
Hi, I'm Monty Mythen, Editor-in-Chief of Top Med Talk. Welcome back to the State of the Art meeting, Intensive Care Society State of the Art meeting, here, live from central London in the QE2. So we're rejoined by Hugh Montgomery, who was with us last night, making some really quite controversial comments at the time. We'll come back to that. We've already had the lawyers on the phone, Hugh.
Thank you.
So we might be able to get some advice on that. And Hugh, to remind us, a colleague of mine from University College London, also working at the Whittington Hospital.
That's right.
Specialist in intensive care.
Correct.
I think technically a professor of cardiovascular genetics and critical care.
Something like that,
I think when you were appointed, that's what it said on the can.
I think that might be it.
You
I missed the first bit off now.
Yeah. Why cardiovascular genetics?
It's where I started, essentially. I drifted into it by mistake. That's been pretty much the whole of my career history, really. It's where my MD sort of started, and it led me into genetics by mistake.
And you're credited with discovering the fitness gene.
I am, the first gene for human performance.
But that's not what we're here to talk about. You brought a very special guest from the last session that you were in. Hugh, would you be kind enough to introduce that guest?
Yeah, well, sitting opposite me is Paul Sankey, who's a lawyer. And you'll be familiar, Monty, as a practicing intensivist, with the pressures we're all facing now about how we make decisions, whether we're allowed to make decisions, who we have to involve. And in fact, we had a little vote at the beginning of the last session we had, and approaching 80% of people say they feel threatened as a matter of routine in their daily practice by litigation. So people are going to work under fear at the moment, thinking that whatever they do may be scrutinised in court.
Now, litigation to what extent? Because I very sadly have been to the High Court as an expert for manslaughter charges against colleagues, in the broadest sense, against anaesthesia providers, who didn't have a great day at the office, not clear if they did anything that terribly wrong, as it turned out in the final conclusion, but they were in court charged with manslaughter.
Right.
And the discussion was that if that rolled over, it would roll over into corporate manslaughter.
Yes.
So in the back of the courtroom were the people, the senior officers in the hospital, who had been told, stay there, because if this stays up the flagpole, you're in next.
Yeah.
Is it that sort of thing that people are stressing about?
It's about that, but it's more to the day-to-day things. So what we've just been discussing with Paul are the issues...
Well, they started off with the day-to-day thing.
Right.
If you see what I mean.
I do.
And they ended up...
So the issues, I suppose, that were being raised in the session, we're going to be talking about manslaughter in a session in about 20 minutes, actually, so I might come back after that with someone else. But we were dealing with issues, for instance, of consent.
Yes.
So how do you obtain consent? How do you know somebody's capacity? What do you need to tell them? What are you in trouble for not telling? Do you need to ask on every single decision? So should you ask every single patient about whether they should have CPR if something goes wrong, even if that is likely to cause mental distress? So I suppose it's worth talking to Paul, since he is the expert on this. We had a case in Britain called the Montgomery, named not after me, a completely different case. So Paul, would you like to very quickly just encapsulate what that case was about and why it's relevant to us as intensivists, what we have to take away from it?
So it was the case that defined the doctor's duty in terms of advising patients and obtaining consent to treatment. And it concerned obstetrics. So Mrs. Montgomery was pregnant in 1999. She was at a relatively high risk of the birth being complicated by shoulder dystocia. So there was a 9 to 10% risk, which is quite a high risk. And the reason for that is that she had type 1 diabetes, she was very short, she was 5 foot high, and she also had a very big baby. The risk could have been avoided by caesarean section, but her obstetrician didn't discuss the risk with her, didn't give her the alternative of caesarean section, and in fact said that had she done so, she thought that Mrs. Montgomery would elect for caesarean section, but the obstetrician formed the view that that wasn't in Mrs. Montgomery's interests. So that's quite a paternalistic approach to advising patients, the doctor taking her view as to what is or isn't in the patient's interest and what risks she should or shouldn't be running. Sadly, the birth was complicated by shoulder dystocia. Her child was brain damaged and suffered a hypoxic injury and has cerebral palsy. She brought a case on her child's behalf, and the case ended up in the Supreme Court, and the Supreme Court took the opportunity to redefine what a doctor's duty is. Now, in the past, the duty had been to do what a responsible body of obstetricians would have done, or if you're talking about intensive care issues, what a responsible body of intensive care doctors would do. But the court said, no, when it comes to advising people, patients, it's not what a body of doctors would think is appropriate, it's what a reasonable patient like this patient would want to know. And in the Montgomery case, the court took the view that she would have wanted to know of the risk of shoulder dystocia, that she should have been empowered to make a decision as to what sort of birth she underwent, and that there was a breach of duty, therefore, in not offering her caesarean section.
Okay, can we replay that again? I think I've got it, and I should understand this at work. The previous test you're referring to, is that what we also used to call the Bolam?
Or is the Bolam test, yes.
Which means if you end up somebody saying, I think you made a bad call, you did the wrong thing, if you can find a reasonable body of practitioners who agree with you, then you might be okay. They might say that was all right. But this is different. This is beforehand.
Well, the difference is the Bolam test still applies. So the Bolam test is the standard of care expected of a doctor is that of a responsible body of doctors practicing that particular discipline. So in the Montgomery case, we're looking at the standard of obstetricians.
So you might have been able to find a reasonable group of obstetricians who said, I would have done the same thing, and the outcome may well have been the same.
Yeah.
But that's not the point here, is it? That's not the...
No, so the Bolam test still applies, but it applies to treatment in particular. When you're considering a doctor's duty in advising a patient, the Bolam test no longer applies. So the Bolam test is very much a clinician-centred test. The standard is set by the medical profession itself. When it comes to advising patients, the court now says the standard is a patient-centred standard. So it's what a patient like this would want to know.
Right. So that's going to vary, right, between patients. So if I'm sitting here with my IQ of 60 and limited life experience, presumably that's a different level of information than giving Monty to my right here, who's got more life experience because he's a year older than me, but is wiser. I mean, how much do we have to tailor what we say to the patient?
Yeah, it's entirely a patient-centred test, and it will vary. It will vary from patient to patient. That's what the court wants to see. It wants to see doctors empowering their patients to make their decisions, and because patients are all different, they have different levels of understanding, they have different concerns, they have different values, they have different things they want to get out of their treatment, different things they want to achieve. So it's going to be the advice is going to have to be tailored to the patient, and it will vary from one patient to another. And it may be that one patient will want to know a lot more about risks and will want to know about a wider range of risks than another patient.
Monty, so let me put this one to you then, because help clarify this for me.
Yes.
I think that my patient needs a tracheostomy. I think it's in their best interest to have a tracheostomy. The patient...
I was thinking exactly that. Yeah. Or a patient may need to go on a ventilator. But keep going down that path.
Okay, so let's suppose the patient has capacity and is conscious. Not heavily sedated.
So they're on intensive care, they're on a ventilator, they've got endotracheal tube in place, but they can communicate. We're convinced they can communicate.
Yeah, make it easy. We think they have capacity and that they can communicate back by nodding or shaking. I presumably have to explain all the potential risks if this person is intelligent enough to understand them, and I feel that they would wish to know them about hemorrhage and tracheal stenosis and any number of other things that might go wrong, right? That's what I'm now legally obliged to do.
Well, it's not quite all the risks. It's more complicated than that.
Go on.
It's the material risks.
Now what's a material risk?
So the way a material risk is defined, it's what a reasonable patient like this patient would consider material to them. So that doesn't make life very easy for you. It means what you've got to do is a judgment call. So I think that you start with the risks. So go through in your mind what are the risks of treatment, and then what is expected is a process of dialogue between you and your patient where you're forming a judgment as to how much information a patient you would expect a patient like that to want to know. And then that's how much this information you disclose. Now, I'm not giving you an easy task.
Okay.
Don't shoot the messenger.
I'm not going to shoot the messenger, but I'm going to make it complicated. So, Monty, I'm just imagining, we consent the patient, we say, look, there's a hemorrhage, there's whatever, and they go, no, that's fine, Doc, you crack on.
Okay, let's play it out, Hugh.
Go on then.
You want to do a trachea on me.
Okay.
And let's imagine I can speak.
Okay. So let's suppose you can speak and we go down a line where you're going to consent to this. I'm going to say, I explain that the tube down your, into your breathing pipe has been there for a long time now.
Yep.
That we've got evidence that the vocal cords that it's going through, your voice box, is getting in trouble now. It's getting very inflamed and it's getting quite tight.
Okay.
Then long term that could be bad for you.
Yep.
And the most comfortable thing for you, and the thing that would be best in my view for your long term health, would be to move the pipe to putting a tube in the neck there. It's something we can do under a bit of light sedation.
Are you sure of that, Doctor?
Yes, I'm...
Does the available evidence support that view? Because I'm in this business, I've read the literature, and I can't find the evidence to support that view.
No, that's right. So
you've just loaded the bases in favour of a prejudice you've brought to the bedside.
No, I don't think I have in this case, Monty. I was quite careful to say I wasn't giving an early tracking compared to a late. I wasn't quoting TrackMan data. That's why I went for the fact your vocal cords are ulcerating and all sorts of other things, because then I'm on pretty solid ground. This is in your best interest. But what happens now if I say this to Monty and I'm saying, look, we're never going to get you off this ventilator because at some point I have to pull this tube out and now you're not going to be able to breathe. So I really have to do this. And Monty's going, nope, you're not doing it. Now what?
Well, you can't compel Monty to have a treatment that he doesn't want to have.
Right.
So patients are perfectly entitled to make their own decisions as to between a reasonable range of treatments. They can't compel you to give a treatment which is not reasonable. But if there is more than one type of treatment that you think is within the range of reasonable options, it's up to the patient to decide.
Okay, so let me just push that one again. Is it now a reasonable option, Monty, to leave the DT... Let's suppose we're now 4 weeks down the line, and the only thing that's stopping this guy coming off a ventilator is the fact that I can't take the endotracheal tube out, because despite a bunch of decks, his cords are so tight that we can't even get a cuff leak. So I've downsized, I've done all the tricks I can. He's stuck on a ventilator simply because he won't have a tracheostomy. Is that still a reasonable treatment? What's the law say about that? Paul is looking worried.
You're putting me on the spot here, and I don't really know the answer to it, frankly. Right. The principles are, your duty as a doctor is to advise of the reasonable range of treatments, to advise of the material risk of those treatments, and then it's for the patient to decide. I think if it comes to the point where a treatment is not reasonable, then you don't have to. You certainly don't have to offer an unreasonable treatment. I think if you think the treatment you're giving should be withdrawn, it's no longer reasonable to give it, I think you could probably withdraw it.
So what happens if I was clear earlier on about my reluctance to have a tracheostomy, and I know your subspecialist areas isn't the unconscious patient. So I'll put this back on Hugh.
Yeah.
Now I'm off to sleep. I've got multiple organ failure, and all the kids have arrived from overseas. Haven't seen me for 10 years, but they thought they better turn up.
Well, this is good because I'm now an expert, having heard 40 minutes of education. So as I understand it, Paul, and you can correct me because I've just been learning about all of this, I've got to act in the best interest of my patient under the law. Right. And I have to assess that best interest by considering what their mental state was before, what their cultural beliefs are, their religious beliefs, what their expressed opinions were.
I expressed my opinions to them.
Okay, so what the expressed opinion was...
I did not want a tracheostomy at that time, because you told it was a bit of ulceration of my cord. Those bad things hadn't happened by that stage.
Okay.
Is it my shout? I'm asleep now. Or is it your shout, what you believe is in my best interest?
Well, my understanding would be that because time has moved forwards, that I now then have to reassess the best interest of the patient. Okay. And whilst he had expressed an opinion 3 weeks ago that I had to respect, now things have moved forward. He lacks capacity, and I now have to act in his best interest. So I would proceed as I understand it.
So one of the factors you take into account is the views that have been expressed to you by your patient. And you take that into account in working out what's in your patient's best interest. But that's not the trump card.
Right.
So there are other factors to take into account.
You're thinking about the least burdensome.
No, I'm not just thinking about that. I'm thinking that the test isn't. It's a best interest test, not a what you might call a substituted judgment test. A substituted judgment would be, this is what he judged to be the most desirable outcome. He's not around to make that decision, but I know that's what he would have wanted, therefore that's what we must do. That's not what the test is. The test is a best interest test. There is some slightly muddled thinking here, but part of... In reaching a view as to what's in your patient's best interest, you take into account their views that they previously expressed or that are ascertainable to you in some ways. But there are other factors to take into account as well. So you look at it in the round.
So, Hugh, when you talked to me, I expressed to you when you asked me, you explained to me the consequence of all of this. I said, I've thought this all through.
Right.
I'm not scared to die.
Right.
I would really, really like to get better and go home.
Yeah.
But I don't want to be incapacitated and dependent in hospital. Okay. But the kids now turn up, and they've got a different view of what they think I might have wanted. Because they spoke to me 8 years ago when I had a completely different attitude to the sanctity of life. I was deeply religious at that stage. I've moved on, and therefore, what are you going to do now? You've got conflicting views of what I may or may not have thought.
Well, my understanding, and Paul can correct me, is that I had this directly from the patient. And I can't overrule the patient's express wishes to me because someone else has interpreted a view from some years ago differently. If the patient has capacity, so they can hear, understand, weigh, and communicate.
I'm asleep now.
You're asleep now, but you have clearly communicated. I can't overrule you because some family members think differently. I think that's right.
Yeah, I mean, the Mental Capacity Act talks about taking into account a patient's wishes and feelings insofar as they're ascertainable to you. They are ascertainable to you because your patient told you.
Yes.
Recently, the fact that the family had a discussion 8 years previously when his views were something different, I think that suggests to you that the more recent conversation is the one that truly reflects your patient's views.
Next session starting in 10 minutes. I know Hugh's got to go. Stay there for 1 second, Hugh.
Okay.
Desiree's just arrived with a quick question, I think. Desiree Chappell, co-host from the USA.
Hi, and jumping in. Going to try. One of the things we experienced when I was working in the ICU is that the patients always overrule, or the patient's family seemed to always overrule what the patient actually wanted. So if they were crying at the bedside and really upset, even though we knew the patient didn't want everything done, in this case of like DNRs and do not resuscitates and things like that.
That's your experience in the States?
In the United States, yeah, and. Power of attorney and who's in charge, even though the family member or the patient themselves told us they did not want to be resuscitated, the family was the power of attorney and they had the ultimate decision. Is that the way it is here?
No, so we have, there are two separate issues there. Firstly, if the patient has capacity, then I have by law to do, if they have a tube in and they're still saying yes, I want to die, are they kind of under duress? I think if we've got clear statement from the patient, then I have to act in their best interest, and that includes I can't do things to the patient they wouldn't want. Mm-hmm. If the patient arrives without capacity and they have delivered a lasting power of attorney, that's a slightly different thing in law here. But my understanding then is that that lasting power of attorney, that person is now representing the patient, and I have to then follow the same process that I would have done before in considering best interests. Is that right, Paul?
That's right. The attorney still has to act in the patient's best interests. So if you think there's a conflict between what the best interests of the patients are and what the person with the lasting power of attorney says, then you have to resolve that conflict. Yeah. Well, you may necessarily have to go to the Court of Protection and seek guidance, or that's a drastic step. I mean.
It's becoming increasingly prevalent in this country, isn't it?
So we're going to come back to that in a later session.
Yes.
Paul Sankey, thank you very much indeed. I don't think when we introduced you, we said where you're from.
Which is your firm?
So I'm from Enable Law, which is part of Foot Anstey. It's quite a large southwest law firm.
Enable Law.
Enable Law.
Thank you very much, and thank you for all of your support for the Intensive Care Society.
Thank you.
It's
a pleasure.
Really helpful. Hugh, you're going to go to a manslaughter session there?
We are. So we had Duck the Doc was our last session. So what do we do to make sure we don't end up in court? But now we're going to be talking about what happens to doctors when they are in the dock.
Right, so I'm definitely coming to that one next. Desiree, thank you very much indeed. Where are you going to next, Desiree? You can work that
I'm still deciding.
Okay, excellent. Thank you very much. Thank you for listening to Top Med Talk.
Thanks for downloading and listening to Top Med Talk. Don't forget to find us on social media. We're on Twitter, Facebook, Instagram, even got our own YouTube channel. Whichever your favourite social media feed is, we're bound to be there. Find us. Also, subscribe to this podcast so that you never miss an episode. And make sure you go to the Top Med Talk website, topmedtalk.com, and get on board with the email updates. Oh, whilst you're at it as well, I suggest you download our entire back catalogue. We're categorising at the moment. We're having a little look through it. It may not always be in the form that you currently find it. So if you get your hard drive ready for a full-on download via the website perhaps, or perhaps through your podcatcher. Oh, and if you fancy meeting us, why not go to the website ebpom.org/meetings. Our next big event is EdPom USA, the Dallas Masters Course, a perioperative care practicum. Have a look for details of that and some of the other meetings coming up across the next year. edpom.org/meetings.